Dear learners, I welcome you all to this course on understanding human rights. In our previous lecture, we discussed about the status of the scheduled caste and the scheduled tribes. We were discussing the what we call in India, what is the status of the vulnerable groups and the major issues of violations of human rights. And we discussed first of all about the status of women and then the status of minorities. And we have been discussing about the status of the scheduled caste and the scheduled tribes. These are the vulnerable groups that we have identified for our discussion here. And then we are continuing our lecture on the status of the scheduled caste and scheduled tribes in India. So far, we discussed the constitutional framework of the protection of the scheduled interest of, or the rights of the scheduled caste and the scheduled tribes. After the constitutional framework or the constitutional provisions, in which we discussed the fund, preamble, the fundamental rights, and then the directive principle of a state policy, and then other provisions of the constitution relevant from the point of view of the rights of the scheduled caste and the scheduled tribes. Now we are going to discuss other legal measures for the protection of the rights of SCs and STs. They are not constitutional measures, rather they are extra constitutional. In addition to the constitutional provisions, or in the light of those constitutional provisions, certain other legislations have been there in the country, keeping in view the challenges faced by the scheduled caste and the scheduled tribes in our country. So the Parliament enacted the Untouchability Offences Act 1955, which prescribes the punishment for the practice of untouchability. You see, the Constitution was drafted and then implemented in 1950. But you see, the untouchability is still practiced. So that is why the Parliament had to enact this Untouchability Offences Act 1955, which prescribes the punishment for the practice of untouchability. The Act was amended by the Untouchability Offences Act 1976 in order to make the laws concerning untouchability even more stringent, and the name of the original Act was changed to Civil Rights within bracket Protection Act 1976. So we have been discussing about the civil and political rights. You will find now the civil rights is being the civil rights of the people from the scheduled caste and the scheduled tribes, especially those who are suffering from untouchability, that have been ensured here, and that's why this is a significant legislation. However, you will find that the reports of the practice of untouchability are received by the National Commission for the Scheduled Caste, and it is also reported in the newspaper. But still, this legislation is significant. However, even after many laws and stringent measures to prohibit this evil practice, to prohibit this evil practice, were made effective, physical violence against members of both scheduled caste and the scheduled tribe did not seem to stop. Brutalities such as murder, rape, torture, arson, and other injuries continued to be inflicted upon these communities. For example, you will find that in the name of witchcraft, many women from the scheduled caste and the scheduled tribes, they have been paraded nude sometime, they have been brutally tortured sometimes, and in many cases they have been killed. And that, they have been subject to collective violence. So that is why the question that can be raised, why most of the time you'll find, or almost in all the cases, the victims of the violence related to witchcraft are women from the scheduled caste and the scheduled tribes. So that is the reality that we have to accept, that these groups are vulnerable, and that's why they need a special protection in the country. Hence, a new law was formulated in 1989 known as the Scheduled Caste and the Scheduled Tribe Prevention of Atrocities Act. That is also there. This act provided for even a stronger punitive measures which could serve as deterrence. So that is why, but you see the constant struggle of the community, you have to see that the people from the scheduled caste and the scheduled tribe, they have been demanding and they have been highlighting their plight, and ultimately the parliament had to respond, and that is why more stringent punishment are there. And of course, it is it is having some kind of effect in the society, because at least now uh, they can claim their rights, and they can identify the culprits and ask the intervention of the state to punish those culprits who are practicing untouchability and committing atrocities against the members of the scheduled caste and the scheduled tribes. Now we are going to discuss the status of the SCs and STs. So we discussed certain provisions relating to the extra constitutional, or in addition to the constitutional framework or the constitutional provisions, some enactments that have been there by the Parliament of India for protecting the interest of the scheduled caste and the scheduled tribes. But what is the reality? What is the position? What is the status of the members of the scheduled caste and the scheduled tribes? We have to see. Despite efforts to minimize the ill effects of centuries of exploitation and discrimination, the SCs and STs continue to suffer even after 76 years of country's independence. That is a reality which cannot be denied. But nonetheless, we cannot deny also that we have made significant progress from untouchability to the provision of reservation for the scheduled caste and scheduled tribe and their representation in the government jobs and the public spaces, that has increased. And thanks to the Constitution of India, and thanks to the progressive approach adopted by the Indian state. Here we find that the National Crime Records Bureau's Crime in India report 2022, which is available here. We have quoted from that report 2022, brings into focus the vulnerability of scheduled caste and the scheduled tribes. According to this report, around 57,582 cases registered for committing crime against scheduled caste in 2022. The data reflects an increase of 13.1% over 2021, when the cases were reported 50,900 cases earlier. But now you will find 57,582. So it means that despite legislation, what is happening, that the crime against the scheduled caste is increasing, which has been already recorded. The highest number of cases, that is 18,428, were accounted for 32% of the total cases were registered under simple hurt, followed by cases under criminal intimidation with 9.2%, and 5,274 cases, and SC/ST Prevention of Atrocities Act with 8.2%, that is 4,703 cases. So you see, that is, when we are talking about, it may sound a minor crime, for example, simple hurt. You see the language that have been used, the simple hurt. But you see, this is a kind of symbolic violence. For example, using the language which is derogatory against the member of the scheduled caste. It affects the dignity. It affects the conscience of the person or the community as a whole. So therefore, it cannot be called as something, a crime which is not big. It is going to affect the person for long, and in some cases, because of this kind of humiliating treatment or some kind of derogatory marks that were passed, some people committed suicide. Some students committed suicide. So that has been also reported. These 4,700 cases involved 4,802 victims also, you see. Of the total cases in this category, as many as 1,735 pertain to FIRs related to intentional insult or intimidation with the intent to humiliate. 305 cases pertain to matters where the accused has prevented, denied, or obstructed usage of public space and passage. You see, that is happening after 76 years of India's independence. And that is quite disturbing, that this is still happening with the members of the people from the scheduled caste. So that is why 305 cases pertain to matters where the accused has prevented or denied or obstructed usage of public space and passage. There were 50 cases of occupation or disposal of land belonging to the scheduled caste person. There were 15 cases involving allegations where the SC person was forced to leave his or her place of residence or faced social boycott. You see, this is happening in the 21st century after 76 years of India's independence, which is quite unfortunate, sad, and of course disappointing. As per the 2022 numbers, Uttar Pradesh, with 15,368 cases, recorded the highest total cases of atrocities against people from the SC category. Rajasthan, with 8,752 cases, stood second, whereas Madhya Pradesh, MP, with 7,733 cases, was on number 3. So now why this is important? Of course, Uttar Pradesh is the most populous nation, most populous state in the country. So that is why it is but for obvious that that from Uttar Pradesh you will find highest number of cases of this kind of cases, atrocities against SC was reported from Uttar Pradesh, then followed by Rajasthan and then by Madhya Pradesh. The three states, they account for first, second, and third highest number of atrocities against the member of the Dalit community in our country. You will find some independent sources are there beside the government. For example, as per the reports of the Quint, the crime rate, that is crime per lakh population, in Rajasthan was 71.6, more than double that of UP, which recorded a crime rate of 37.2. At the same time, so here you'll find that UP is doing better than Rajasthan, where the crime rate is higher. At the same time, Rajasthan's charge sheeting rate was 45.9%, which means that a charge sheet was filed in only 45.9% of the recorded cases. In UP, the charge sheeting rate stood at 84.9%. Again, you see the UP better than Rajasthan here if you compare. On the other hand, a total of 10,064 cases were registered for committing crimes against scheduled tribes, showing an increase in 14.3 over 2022, that was 8,802 cases. So, this increase is significant. That should be again seen. We should have noticed that, the crime against scheduled caste and scheduled tribe is increasing, not it is decreasing. That is quite disturbing. That despite legislative measures, constitutional framework, institutional mechanism, they are continuing and rather they are increasing. So it means that the legal framework is not working in a manner it should have worked, and rather it is the social hostility that is faced by these communities and that increases their vulnerability. In terms of categories of crime, the highest number of cases at 28.1% were registered under simple hurt, that is 2,826 cases. Again, simple hurt, I told you, or I was explaining that, it is not a minor kind of crime. The simple hurt, some kind of derogatory remarks by a teacher in the class or by an employer in the office, that can damage not only the reputation, but it can disturb the person who has suffered for life. And, withdrawal syndrome and other things can be there. And I was also discussing that when it is happening in the public spaces, for example, in the schools, colleges, universities, where the young students are studying, that is quite disturbing. And especially, it cannot be expected from the in the academic spaces. But it has happened, and this kind of report you will find from the universities and colleges also. So that is why the simple hurt itself is a major crime against the members of the scheduled caste and the scheduled tribe, I think, and it cannot be acceptable at all. Another important issue is the heinous crime, and that is, of course, the heinous crime is rape with 13.4%, that is 1,347 cases. About rape, we must know that the reports that most of the rape cases are not reported because of the social taboo. So the victim is hardly coming out or going to the police station to report the cases. And what happens that the cycle of exploitation is there, and that's why the rape continues for years. And it has been found by many NGOs and the human rights activists that the people from the vulnerable communities, women and girls, they were bearing this for many years, and they were not able to muster courage to go to the police to report. And in many cases, you will find there was a lot of pressure, political pressure on the police, and that is why the police itself was not able to intervene. So, under these kind of circumstances, you will find that the role of the NGOs or the human rights organizations and the activists becomes important. So, ultimately, when we are talking about 13.4% cases, we should remember that many of these cases, rather, in many cases, women or the victims, the girls, they are not going to the police station to report, and that is why it is not there. Assault on women with intent to outrage her modesty in 10.2%, that is 1022 cases. Then most cases of atrocities against people belonging to the SC/ST category were recorded in MP, that is 2979, followed by Rajasthan, that is 2521, and then Odisha 773. So you'll find that atrocities against people belonging to the ST category, that is also there, which has been reported in these states. While MP and Odisha 99.8% and 94.9% respectively saw high charge hitting rates, Rajasthan charge hitting rate remained low at 44.3%. And most of the time when the charge hitting rate is low, the political intervention is something that is a factor, you'll find. As per the reports of the various media outlets like Times of India, more than 1.9 lakh cases of crime against Dalits were registered in 4 years from 2018 till March 2023. You see, 1.9 lakh cases of crime against Dalits. So this is happening again, you see, in independent India, and that too after 76 years of India's independence. As many as 49,613 cases of atrocities and attacks on Dalits were registered in Uttar Pradesh. And you see, 11,924 in 2018, 11,829 in 2019, and you see that then you will find 12,714 in 2020 and 13,146 in 2021. Why I read this statistic? Because you will find, the graph is like this. There is significant increase in the number of cases of atrocities and attacks on Dalits. So the increase is there, and that is disturbing. And that is, of course, an area of concern which needs, of course, the intervention by the policymakers. A total of 1,89,945 cases of crime against the community were registered in 4 years. That is, again, you will find 42,793 in 2018, then 45,691 in 2019, 50,000, you see, 2091 in 2020, and then 50,900 in 2021. Again, you see the increase. You see the graph is like this. So, despite all the measures that the government of India has adopted, or the Indian state has adopted, you will find that the atrocities against Dalits and the scheduled tribe continues in the country. Rather, there is increase as well, and the increase is significant. Till 2021 end, over 70,818 cases of atrocities against Dalits await investigation, and 12,159 against SCs. So they are still under investigation. Uttar Pradesh में social activist Naresh Paras said, data presented in parliament is based on the FIRs registered. And this reality should be realized by all of us, that the data presented in parliament is based on the FIRs registered. The ground reality is worse. Crime against Dalits is on the rise. Governments need to study the matter in detail by involving activists, public representatives, and civil society. Unquote. You see, and that is why Naresh Paras's statement or observation is quite significant here. He further added that this community is not only the victim of the caste system but also faces institutional discrimination and social exclusion. Institutional discrimination, that is uh, something institutional uh, discrimination. It means that in the public institutions, for example, in the universities and colleges, or for example, at the places where they are employed, so the institutional discrimination and then social exclusion, denying opportunities to the community, that is the scheduled caste and scheduled tribe, that is there. So this restricts or prohibits or prevents their upward mobility, and that's why withdrawal syndrome is noticed. The scheduled tribes, on the other hand, are fighting for Jal, Jungle, Jameen, that is Zameen, of course. The scheduled tribes community, it is one of the significant issues, that one of the significant issues that they are facing is the Jal, Jungle, Zameen. It means that the issue of displacement. It is important to remember here that the slogan Jal Jangal Zameen, water, forest, land was coined by the Gond tribal leader Komaram Bhim in the early 20th century. And the slogan was coined to claim the rights of the tribal people over forest and land. So, the forest dwellers communities, especially the Adivasis, they have been, raising this slogan, Jal Jangal Zameen. What is happening? That because of the corporatization of spaces in the country, especially in the post-globalization phase, a lot of, developmental activities that the state claims or the government claims, and what the people from the Adivasi community, they think that this is disturbing the ecosystem of the area where they have been living for centuries in complete harmony with the jungle. So what is happening that their water is being contaminated because of the mining and other developmental activities that the state is carrying out. So that is happening. So their water, ponds, for example, or whatever water sources that are there, so they are being destroyed because of that water is becoming contaminated. On the other hand, you will find that it is not only water is being contaminated. You will find in many tribal areas, the multinational companies, they are drawing mineral water from there and they are using it for commercial purposes. That is also, creating ecological imbalance. On the other hand, we find that it is not only Jal but Jal, Jungle, Zameen. Their land, most of the time held in common, is also being uh, taken away by the state, and that is why that is creating problem for them, not only by the state but also by the people, those who are in a dominant position. So again, that is they say that our struggle is for Jal, Jungle, and Zameen, and they have to also they want that the forest should be preserved. The deforestation, something we have been talking about in the environmental rights when we were discussing. But you'll find that these people, they have been living in the jungles in complete harmony with nature, and this is the reason now they are fighting for what is called Jal, Jungle, Zameen, which has become a very important issue for all the people from the Adivasi community or the forest dwellers who have been living in the jungles. Sai Thakur wrote in a column in Hindustan Times, and this is significant, I quote here: the tribals claimed a symbiotic relation with the land and forest that they inhabited. Jal, Jungle, and Jameen were not resources to be extracted for profit. Very significant, you see. So, the Jal, Jungle, Zameen, that is not for commercialization. It is a gift of nature that should be, that should be valued. So it is not to be extracted for profit, but an inalienable part of their tribal identity, and thus had to be protected and nurtured. Unquote. And I think this statement itself is capturing the spirit of this Jal Jungle Zameen movement. And that is why this is important here, that the commercialization of the jungle and the resources that are there in the jungle, whether it is wood or whether it is herbs and the shrubs that are there, that are being used for the commercial purposes, medicinal purposes, and how that is leading to destroying the jungles and all. So that is why this is being raised here, and Sai Thakur's statement that is here is quite significant, which is capturing the spirit of this movement for Jal Jangal Zameen. That is a struggle waged by the people from the Adivasi community. And I think this is one struggle that will also promote what is called the ecological balance, or that will also protect our environment from destruction. These people, especially the scheduled tribe people or even some scheduled caste, they are the victims of development. These are the areas where they have been inhabiting for centuries. Now what is happening, that they are being displaced, and when they are being displaced, you will find the rehabilitation is not there, or they are not being adequately rehabilitated. So they become what we call the victims of development, and in many cases they are just like internally displaced persons. It is not rehabilitation according to the tribal leaders or the leaders from the scheduled caste. It is just uprooting the people, from the area or from the ecosystem where they have been living for centuries. So that uprooting is something that they resist. So that is one of the issues that is highlighted by the people from the scheduled tribe in our country. At many places, the Adivasis have been displaced from where they have lived for centuries. Displacement without adequate rehabilitation is the major problem faced by Adivasis in our country. That should be understood by all of us. With this, we are going to conclude our discussion on the status of the scheduled caste and the scheduled tribes. And what we find in conclusion, what we are going to understand, first of all, we find that the people from the scheduled caste and the scheduled tribes, they are the vulnerable groups of the country, and their vulnerabilities increases. Why? Because of the caste system that has been there in our country, and these people, they are either they are considered as outcast or at the lowest ladder of the Varna system. That is one problem. So that is why they have been facing this exploitation for centuries. Secondly, we find that the discrimination against the people from the scheduled caste and the scheduled tribe that have been there, it is not a new phenomenon. It did not start with colonialism, but it has been there since ancient times. So that is why it is centuries old exploitation that they have suffered, and that has led to their backwardness and marginalization. So when you are trying to identify the marginalized and the socially excluded communities, I think that the people from the scheduled caste and the scheduled tribes, they will be there. So this is one thing that is to be realized. Thirdly, you'll find that the framers of the Constitution of India, they showed sensitivity when they recognized or they gave attention to the plight of the scheduled caste and scheduled tribes. So you'll find that there are constitutional provisions in which this community or their vulnerabilities have been acknowledged, and they have been given a special, some kind of a special rights, and the special clauses are there for the protection of the interest of the scheduled caste and the scheduled tribes. For example, the seats are reserved in the Parliament of India and the assemblies and the panchayats and the municipalities and corporations for the members of the scheduled caste and the scheduled tribes. So that is what we call the promoting political democracy and ensuring the representation of the members of the scheduled caste and the scheduled tribes. However, you find that the claim of many leaders of the scheduled caste is that, or the scheduled tribe is that, because of the joint electorate, what happens that in most of the time they are not able to, the leaders of the scheduled caste and the scheduled tribe, they are not able to assert, their position as the leaders of the community, and rather because they have to satisfy the aspirations and the expectations of the people from other caste as well. So that is why they do not become the real leader of their community. That is one of the complaints, but you can say it cannot be denied that this reservation has of course led to political representation or of the scheduled caste and the scheduled tribes in the political spaces, and it also deepened the root of Indian democracy or the base of Indian democracy. On the other hand, you will find that the reservation in the public employment and in the education institution that have also led to the amelioration of the condition of the scheduled caste and the scheduled tribes. So for that, Indian state and the Constitution of India must be appreciated. We find that there are other legislations, for example, despite these kind of constitutional framework, the people from the Dalit community especially, they have been facing untouchability, discrimination, atrocities, etc. So that is why there are certain other legislation beside the Constitution of India, and that is to protect the members of the scheduled caste and scheduled tribes from atrocities and from the disadvantages they have been suffering because of the social hostility they face. So that is also there. But despite all these efforts, what we see that the condition or the status of the scheduled caste and scheduled tribe is not very good in our country. If you compare the life expectancy or if you see the malnourishment, underweight people, we will find most of the people they will come, or the percentage of the malnourished children or the underweight people that will come from this particular group that is we have identified. Another important issue is that you will find after 76 years of independence, the reports of discrimination, humiliation, or hurt or derogatory remarks, they are still there in the newspapers and on the TV channels. So that is what we have to realize, that although we have made progress, but a lot needs to be done for uplifting the scheduled caste and the scheduled tribes in the country. And this is the reason that affirmative action of the state and then the policies that are there to to provide help and assistance to these communities, that is must. With this, we are going to conclude our discussion on the status of the scheduled caste and the scheduled tribes in India. And let me acknowledge that due to paucity of time, I have not been able to highlight all other issues that these vulnerable groups encounter. But again, you'll find that the suggested reading is there, and you can understand in the light of these this discussion, you can understand the plight of the scheduled caste and the scheduled tribes, and you can also go for further reading and better research work on this issue. Thank you very much.